afternoon. Thank you for being here today. This is our first family webinar of the 2025-2026 school year, and I hope the information that you gather is beneficial to your family. Our topic today is Know Your Rights. This will be a brief overview of the Notice of Procedural Safeguards. My name is Sarah Untersee, and I am the School Family and Community Engagement Consultant here at Region 10 Education Service Center. Joining me is Jim Wright with Partners Resource Network. Today's webinar is being recorded and will be available on the Region 10 website in approximately 7 to 10 business days, and we'll place a link to the PDF version of today's slides in the chat. Today we will walk through all the sections of the Notice of Procedural Safeguards document. While this may not be the most exciting topic, it is very important. When should I receive a copy of the procedural safeguards? So IDEA requires that school districts and charter schools provide the procedural safeguards once a year and on the following occasions: upon initial referral or request for evaluation, first occurrence of a filing of a due process hearing or special education complaint during a school year, if there is a disciplinary change of placement, and also at any time there is a request from a parent. Language requirements. Schools must provide a copy in the parent's native language or other mode of communication, unless it is clearly not feasible to do so. SpedText has translated the procedural safeguards and the ARD guide into over 30 languages, and both documents are available on the SpedText website. On page 1 of the procedural safeguards, we talk about foster parents. So a foster parent for a child with a disability may serve as the parent as long as they agree to participate in making special education decisions and complete the required training before the child's next ARD meeting, but not later than 90 days after they begin acting as the parent. Surrogate parents are also covered on pages 1 to 2. So if after reasonable efforts, the school cannot identify or find the parent of the child, or if the foster parent is unwilling or unable to serve as the parent, or if the child does not reside in a foster home setting, if the child is a ward of the state or an unaccompanied homeless youth, the school must appoint a surrogate parent to act in place of the child's parent, unless the child is a ward of the state and the court has appointed a surrogate parent. Surrogate parents must complete the required training before the child's next ARD meeting, but not later than 90 days after the initial appointment as the surrogate parent. Child find. So child find means that all children with disabilities that are living in the state who need special education services must be located, identified, and evaluated. So this includes children with disabilities that attend private schools or who may be homeschooled. Prior written notice. The public school must provide you with certain written information, and this is called prior written notice. You may hear this referred to as PWN. Prior written notice must be provided by the school before it proposes or refuses to change the identification, evaluation, educational placement, or special education services provided to a child. The school must provide prior written notice, even if you agreed to the change or requested the change. And the school must give you prior written notice at least 5 school days before it proposes or refuses the action, unless you agree to a shorter time frame. Parental consent. Parental consent must be informed. Informed consent means that you have been given all of the information related to what the school is asking permission to do. Parental consent is voluntary. Granting of your consent is voluntary and can be revoked at any time, but it must be done in writing, and revoking consent is not retroactive. Parental consent is required before conducting an initial evaluation for special education, to provide special education services to a child for the first time, to reevaluate a child unless the school can demonstrate that it took reasonable measures to obtain your consent and you failed to respond. Independent Education Evaluations, or IEE. If you disagree with an evaluation that was provided by your child's school, you have the right to request that your child be evaluated at the school district's expense by someone who does not work for the school. When you ask for an IEE, the school must give you information about its evaluation criteria and where to get an IEE. From pages 5 to 8, this document talks about discipline procedures. So if your child violates the school's code of conduct, the school must follow certain procedures if it removes your child from their current placement, and if that removal constitutes what's considered a change of placement. So for up to 10 school days, your child can be suspended during one school year without it creating a change of placement. But for more than 10 school days, it is considered a change of placement. And in the admission, review, and dismissal, or ARD committee, must meet and conduct what is called a manifestation determination review, or MDR. A manifestation determination ARD committee will review all the relevant information, will determine if the misconduct is a manifestation of the child's disability, or if it's the result of the school not implementing the student's individualized education program, or IEP. Is the misconduct a manifestation of the child's disability? If the answer to that is yes, if no behavior intervention plan, or BIP, is in place, the school will conduct a functional behavior assessment, an FBA, and implement a BIP. If there is already a BIP, we will review and modify the BIP. If the misconduct is not considered to be a manifestation of the child's disability, then your child can be disciplined in the same manner and for the same duration as non-disabled children. Your child must continue to receive free appropriate public education, or FAPE. If your child's conduct was the direct result of the school's failure to implement the IEP, the school must take immediate steps to remedy those deficiencies. Your child must be returned to the placement from which they were removed unless the misconduct involves a weapon, illegal drugs, or serious bodily injury to another person. There are protections for children who have not yet been determined to be eligible for special education if the school had knowledge that the child had a disability before the behavior that resulted in disciplinary action. Education records. We are on pages 9 and 10 of the Procedural Safeguards document. So upon your request to review your child's records, the school must make them available without unnecessary delay and before any ARD meeting, due process hearing, or resolution session, and no later than 45 calendar days after the date of the request. Is there a fee? If you request copies of your child's records, the school may charge a fee for copying if the fee does not keep you from being able to inspect and review the records. Consent. Your consent, or the consent of the adult child, must be obtained before education records can be released to people or organizations outside of the Texas public school system. Private school placement by parents. Parents have the right to voluntarily place their child in a private school, but federal regulations do not require a public school to pay for the cost of education, including special education and related services for a child with a disability at a private school or facility if the public school made free appropriate public education, or FAPE, available to the child. Transfer of parental rights. All parental rights under federal regulations transfer to a child once that child reaches the age of 18 in Texas. At the age of 18, a student has the right to make their own educational decisions. The school must still provide parents with notices of ARD committee meetings and prior written notices, but they may not attend the ARD meeting unless the adult student specifically invites them to the meeting or the adult student gives them that right in a supported decision-making agreement. On or before the student's 17th birthday, the school must provide you written notice about the transfer of parental rights to your adult student, unless you have obtained guardianship or the student signs a valid power of attorney or a supported decision-making agreement. Resolving disagreements. This is pages 12 through 19, so it kind of takes us through the end of the document. So there may be times when you disagree with the actions that are taken by the school related to your child's special education and related services. Families are strongly encouraged to work with school personnel to resolve differences when they occur. Dispute resolution is a very broad topic, and there's a lot of relevant information. We will only touch on the various options available during today's presentation. Some of the links that are on our additional resources slide contain more information about resolving disagreements if this is an area where you would like to learn more. TEA offers 4 options for resolving special education disagreements. These are state IEP facilitation, mediation services, special education complaint resolution, and the due process hearing program. State IEP facilitation. What is it? As required by federal law, this is a project established by TEA that provides independent facilitators to help parents and schools resolve disputes during an ARD meeting. When can it be used? The disagreement must relate to an ARD committee meeting where mutual agreement was not reached on at least one of the required areas of the IEP, and the ARD committee agreed to recess and reconvene. It must be requested within 10 calendar days of an ARD meeting that ended without mutual agreement. Conditions for facilitation. Both parties must complete and sign the request form. The issue must not relate to manifestation determination or an IAES placement. Parents in the school must not be concurrently involved in mediation, and the issues must not be the subject of a special education complaint or a due process hearing. The parent and the school must not have participated in IEP facilitation concerning the same child within the same school year. Mediation services. What is it? Mediation is a voluntary process used to resolve disputes between parents and schools regarding any matter under IDEA. The goal of mediation is to assist the parent and the school in reaching agreement. Mediation is available to resolve disputes regardless of whether or not a parent has filed a due process complaint. It cannot be used to delay or deny a parent a due process hearing. Who provides mediation? The TEA arranges and funds mediation services. Mediators are impartial professionals with no ties to the school or TEA. Mediators are trained in resolving disputes and have knowledge of special education law. Conditions for mediation. Both parties must agree to participate in mediation. The discussions are confidential and cannot be used in future hearings or legal proceedings. If an agreement is reached, it is put in writing and becomes legally binding. TEA automatically offers mediation each time a due process hearing is requested. Special Education Complaint Resolution. What is it? This is a formal procedure offered by TEA to resolve disputes regarding the violation of special education requirements under IDEA. Who can file? Any individual or organization, including those from other states, can file a complaint. Complaints must be filed within 1 year of the alleged violation. Key steps. A party must submit a written complaint describing the special education violation, facts on which the complaint is based, parent signature, and contact information. TEA will give both the complainant and the public agency the chance to respond to the complaint and to submit a proposal to resolve the complaint. Within 60 days of receiving a complaint, TEA will conduct an investigation and issue a written decision. If TEA has found a failure to provide appropriate services, corrective actions may be required, such as compensatory services or monetary reimbursement. The TEA's decision is final and may not be appealed. Filing a complaint does not take away the right to request mediation or file a due process hearing. If a complaint is filed about the same issues being addressed in a due process hearing, the TEA will set aside those issues until the due process hearing is resolved. Due process hearing program. What is due process? This is a legal process to resolve disputes between parents and schools regarding a child's special education. Due process hearings are conducted by an impartial hearing officer. Who can file? A parent or school can request a due process hearing from TEA on any matter relating to the identification, evaluation, or educational placement of their child, or the provision of FAPE to their child. How is a due process hearing requested? In order to request a hearing, a due process complaint must be submitted to the other party and filed with TEA. Due process complaints must be filed within 2 years of the date of the alleged actions that form the basis for the complaint. Complaints must include the child's name, school, the issue, and a proposed solution. Before the hearing, schools and parents must attempt to resolve the issue in a resolution meeting within 15 days. What happens during the due process hearing? TEA provides impartial hearing officers to conduct hearings. Parents can represent themselves or have legal representation. Both sides can present evidence, cross-examine witnesses, and receive a written record of the hearing. What are parental rights at hearings? Parents have the right to have their child present at the hearing, open the hearing to the public, and have the record of the hearing, findings of fact, and decisions provided at no cost. What happens after a due process hearing? The hearing officer issues a decision within 45 calendar days after the resolution period ends. Any party that does not agree with the hearing officer's decision can file a civil action in state or federal court. Appeals must be filed within 90 days of the decision. The school must implement the hearing officer's decision, even if it appeals, within 10 school days. If parents win the due process hearing, the court may award attorney's fees. Schools may also be awarded fees if the parent's complaint is found to be frivolous or filed for improper purposes. We have some additional resources that are available on the SpedTech's website that are about parents' rights. We have what is the Individuals with Disabilities Education Act, or IDEA. This is going to be an overview of that federal law about special education. We also have another document that's called Parents' Rights, an overview of special education evaluations. What is an IEP? Some information on the special education complaints process, and one about resolving issues with your child's school. The final link on this slide is going to be a link to all of our recorded webinars that are on the SpedTex website. These are statewide webinars that are held with TEA, and one of the webinars that's located on that page was about dispute resolution in special education. SpedTex is the Special Education Information Center for Texas. We're a collaborative project between Region 10 Education Service Center and Texas Education Agency. We help parents to understand their rights and responsibilities under IDEA and facilitate collaboration when there are concerns between the parent and the school district. We also serve as a resource for educators. We offer support via phone, email, or live chat for families and professionals, webinars, and resources, and our contact information is on the screen. You can create a MySpedTex account at the SpedTex website. With a MySpedTex account, you are able to receive customized reminders, volunteer to participate in focus groups, and share your feedback. You can locate resources that are tailored to your needs and access trainings. You can also follow us on social media. We are on Facebook and Twitter, or X both, and we are at SpedTex on both of those social media platforms. And now I will turn it over to Jim to share a little bit of information about Partners Resource Network.
Thank you, Sarah. Partners Resource Network is a nonprofit that's funded by the Department of Education. We serve as Texas PTI, Parent Training Information Center, as defined in the IDA law. We support parents and their questions and how they advocate for their children. We have trainings, and we work collaborative with TEA to help bring this information to parents to help them increase their capacity to be able to work with their schools better and to understand their rights more. And one thing I do love about the procedural safeguards is that, fortunately, no one really reads it until they have to. But the way it's designed, it brings the parties together to resolve the conflicts. Every step of the way is designed to, bring the groups together to better serve the child. And that's what I do really appreciate about how it's structured and how TA supports our students and educators. Thank you.
So you can connect with us. This slide has some links. You can sign up for the monthly SpedTex newsletter. You can also sign up to be notified of upcoming Region 10 family events and sign up for the Partners Resource Network newsletter. For anyone that may be watching this as a recording, you are welcome to reach out, and we are happy to send you these slides so that you can access those as well. Thank you again. Bye-bye.